everyone. Welcome to Unit 7 Leases, the lifeblood of our industry. Let's get right into it. Today, you're going to learn a little bit about defining the four different kinds of leasehold estates, summarize the provisions of a valid lease, and discuss the type of leases and lease formats, explain the process of qualifying the tenant, discuss lease negotiation, the advantages and disadvantages of various owner concessions, and summarize the final process of obtaining the lease agreement. Let's get right into it.
Overview. The management contract formalizes the relationship between the property owner and the manager and specifies the rights and duties of each party. The lease sets up the rights and obligations of the landlord, owner, manager, and the tenant. This unit discusses the estates and tenancies created by the lease as well as ways that rents are determined. As a lease is a contract, it must have certain essential elements, and additional common provisions are discussed. All states and some cities have various laws regulating leases and the landlord-tenant relationship. Property managers must have a thorough understanding of those laws affecting the jurisdictions in which they operate. Depending on the terms of the management contract, the property manager usually has responsibility for leasing the premises. Even those managers who have no active role in leasing should be consulted when drawing up the terms of the lease. Their knowledge of the costs and requirements for operating and maintaining the premises will have a direct impact on the lease terms. Although the attorneys for the parties to the lease are responsible for its legal and technical details, property managers should be familiar with leasehold estates and basic lease clauses. It is most helpful to the transaction when property managers can cooperate knowledgeably with attorneys and leasing brokers. Leasehold estates. Learning objective list and define four kinds of leasehold estates. A leasehold estate is of limited duration and is created when an owner or a property manager acting as the owner's agent grants a tenant the right to occupy the owner's property for a specified period of time in exchange for some form of consideration. The leasehold estate establishes a relationship that creates enforceable rights and duties for both parties. Estate for years. An estate or tenancy for years is actually a misnomer. This tenancy is characterized as having a definite beginning and a definite end, which can be as little as a week, or as long as 99 years, or even longer. At the end of the lease, neither party is required to give notice that the lease is over. The tenant surrenders the property to the landlord. An estate for years is not terminated by the sale of the property or the death of either the tenant or the landlord. If either dies, the rights and obligations continue to their heirs. Because an estate for years has a definite end, if the landlord wants notice that the tenant is planning to leave at the end of the term, the lease must contain a clause requiring the notice within a stated period. Although some states recognize an enforceable oral lease for less than a year, the prudent manager will put such agreements in writing. Estate from period to period. An estate from period to period or a periodic lease is one that automatically renews unless either party gives notice of termination. These leases run week to week or month to month or year to year. Notice is often equal to the period, but the time of notice may vary from a minimum of 1 week to a maximum of 6 months prior to termination. This type of estate is not terminated by the sale of the property or the death of the owner or the tenant. An estate from period to period may be created either by agreement or by operation of law. Express agreement is made when the owner actually leases the property to a tenant to hold from year to year. Many residential leases are a combination of both an estate for years and a periodic lease. They begin as an estate for years, either a 6-month lease or a 1-year lease, and convert to a periodic lease. A periodic estate arises by operation of law when a tenant has possession of the property and pays rent under an invalid lease or a lease that does not specify the duration of the tenancy. The frequency of rent payments in this case will determine the period of the estate. If rent is payable monthly, the tenancy is from month to month. The leasehold interest of a holdover tenant can be limited to a month-to-month extension by inserting an appropriate clause in the original lease agreement, and it is often in the property manager's best interest to do so. An estate from period to period may also be created by operation of law when a tenant holding an estate for years remains in possession of the premises after the expiration of the lease. Acceptance of rental payments by the owner or property manager is considered legal proof of the owner's acquiescence to the holdover tenancy. Laws in most states consider a holdover tenant's leasehold interest to be of the same duration as that specified in the original lease agreement, up to a maximum term of 1 year. Tenancy at will. Tenancy at will is for an indefinite period of time. It exists only as long as both parties wish the estate to continue. In the past, an estate at will could be terminated without notice, but most states now require the party who wishes to terminate the tenancy at will to give some advance written notice. Property managers should consult their state statutes for the rights and obligations involved in tenancy at will. Unlike an estate for years or an estate from period to period, an estate at will is terminated by the death of either party. Tenancy at sufferance. Tenancy at sufferance occurs when a tenant obtains possession of the premises legally, but then remains on the property after the expiration of the leasehold interest without the consent of the owner. This tenant has no right to possession. This tenancy continues until the owner brings legal action or the tenant voluntarily leaves. An example of an estate at sufferance is the tenant who fails to surrender possession of the premises on the date specified in the lease agreement. The owner or the property manager, as the owner's agent, has two options when dealing with a tenant at sufferance. He may, under the common law, either evict the tenant without notice or acquiesce to the tenancy. The owner's acceptance of rent payments constitutes acquiescence and creates an estate at will or an estate from period to period. This is a complex issue, and the property manager can sidestep costly legal entanglements by ensuring that the written leases conform to local laws and statutes. Special lease provisions can sometimes alter or clarify the rights and obligations of the parties. Again, always consult state statutes. Provisions of a valid lease and lease formats. Learning objective. Summarize the provisions of a valid lease and discuss types of leases and lease formats. The basic elements of a lease include complete and legal name and signatures of both parties, description of the property, term of the lease, consideration or amount of rent, time and method of payment, use of premises, rights and obligations of both parties, and possession of the premises, names and signatures. A lease is both a contract and a conveyance of an interest in real estate. It must contain the names of both the lessor and the lessee and must be signed by the property owner or a legal representative of the owner. The power to execute leases can be delegated to the property manager under the terms of the management agreement. All parties should receive a copy of the agreed upon terms. Some landlord-tenant laws permit an enforceable, unsigned lease in some circumstances. The manager should check local laws. If the tenant and all other involved parties have not signed the lease, the property manager may have problems enforcing the lease terms. Practically speaking, the manager should make sure that the tenant does not take possession of the premises until after the lease is signed. If the tenant is an organization or corporation, the lease must be signed by an authorized officer of the corporation and affixed with the corporate seal, if required by state law. The requirement for additional signatures from witnesses and an acknowledgement seal from a notary public varies from state to state, but witnesses and notaries generally are not required for leases of less than 1 year. Description of the premises. A lease for a portion of space in a particular building, such as an office or apartment, must accurately describe the bounds of the space itself. If the rental property includes land, which might be the case when leasing industrial or commercial space, the lease agreement should include a legal description of the property. The apartment number and the street address of the building are usually sufficient identification in an apartment lease. For commercial space, a floor plan showing the area to be leased should be appended to the lease. Term of the lease. The lease should specify the beginning and termination dates, as well as a statement of the total period it covers. This can be done in a clause that reads, for a term of 30 years beginning June 1st, 20XX and ending May 31st, 20XX. It should be noted that residential leases are much briefer than those for commercial, industrial, or retail leases. An option to renew the clause allows the tenant to extend the lease for an additional period of time on specified terms. To take advantage of this option, the tenant merely gives sufficient notice of intent. The option clause states the date by which the tenant must give notice, the form of notice, how and to whom it must be delivered, term of renewal, and rate of compensation. It could read as follows. At the expiration of the term specified in section, article, said term shall be extended, at the option of the tenant, for an additional subsequent period of valuable consideration. All lease contracts must contain some type of valid and valuable consideration. Typically, consideration consists of the exchange of promises. The owner promises possession and the tenant promises to pay rent. Whether the lease is gross, net, or percentage, the amount and time of payment of rent must be clearly specified, as must the amount of property. When rent is expressed or quoted on a square foot basis, it is assumed the figure is per square foot per year. Possession of the premises. Property owners in most states are obligated by contract to give the tenant actual occupancy of the premises described in the lease. If the premises are still occupied by a holdover tenant on the date of the new lease, the property owner or an agent of the owner must take action to recover possession and bear the cost of this action. In other states, owners need only convey to the tenant the right of possession. In this case, it is the tenant's obligation to bring any court action necessary to secure actual possession. Step-up clause. Step-up clauses are found in both gross and net leases. The step-up clause provides for specific rent increases at specific times. These leases are also called graduated or escalation leases. A long-term lease for a luxury apartment, for example, might require monthly payments of $1,800 for the first 2 years, $1,900 during the third year, and $2,100 for the last 2 years. Step-up clauses are often used with commercial space to help a new business or professional get started. Following is a typical step-up clause. The lessee hereby covenants and agrees to pay to the lessor as rent for said premises during said term the sum of $68,100 per term payable at the office of lessor or of lessor's agent in monthly installments, each in advance upon the first day of every calendar month during said term, payable as follows at the office of the lessor or the lessor's agent: $850 per month for the first 666 months, $1,100, $1. $100.00 per month for the next 42 months, $1,400, $1,400.00 per month for the last 12 months. Step-up clause. Step-up clauses are found in both gross and net leases. The step-up clause provides for specific rent increases at specific times. These leases are also called graduated or escalation leases. A long-term lease for a luxury apartment, for example, might require monthly payments of $1,800 for the first 2 years, $1,900 during the third year, and $2,100 for the last 2 years. Step-up clauses are often used with commercial space to help a new business or professional get started. Following is a typical step-up clause. The lessee hereby covenants and agrees to pay to the lessor as rent for said premises during said term the sum of $68,100 per term payable at the office of lessor or of lessor's agent in monthly installments, each in advance upon the first day of every calendar month during said term. Percentage lease. The percentage lease provides for a rise in the rental rate as the tenant's gross or net income increases. This is most often used when renting retail space. Index lease. Because the income from professional offices, service firms, financial institutions, brokerage houses, and similar businesses cannot be reasonably and effectively adapted to the percentage lease pattern of rental payments. An increase or decrease in rent from such sources is often tied to a selected index of economic conditions. For this reason, such leases are called index leases. The index used in establishing the escalation clause must be reliable and published on a regular and continuing basis by an independent, reputable agency. It should bear a close relationship to the nature of the tenant's business. The most frequently used indexes are the Consumer Price Index, Cost of Living Index, and the Wholesale Price Index. Escalation clause. An escalation clause can be tied to outside factors other than economic indexes. Union pay scales, taxes, utility rates, and overall operating costs for the premises are common controlling factors. When operating costs are used as the basis for an escalation clause, the tenant usually is responsible only for expenses in excess of a negotiated amount per square foot. This provision is most commonly found in office building leases and is called an expense stop. When all operating expenses of a building are totaled and charged on a pro rata basis to all tenants, the computation is called a pass-through. Ceilings are sometimes imposed when escalation clauses permit rent increases based on the average increase of the other rental rates in the building. Reappraisal lease. Another method of rental rate adjustment is found in a reappraisal lease. At set periods, often 5 years, or at the end of a term followed by an option, the parties agree to accept a market rent that will be determined by independent appraisers. Tax and insurance participation. The longer the lease, the more likely problems can arise from sudden and unanticipated increases in property taxes. As a result, many leases contain a provision for tax participation. These clauses require the tenant to pay, in addition to the monthly rental, a pro rata share of any increase in taxes or assessments in excess of those expenses for an established base year. Given the present economic climate, such tax participation provisions afford valuable protection for the owner's investment. A similar provision for insurance is becoming more common. State and lease specific provisions. The lease provisions treated in the following discussion cover the major points that must be resolved to create an effective, mutually beneficial contract. The specific manner in which each of these issues is handled varies widely from lease to lease in response to the divergent needs of the parties and different state statutes. Property managers should discuss with the property owner and consult with state law to determine their latitude in regulating the use of the premises, subletting privileges, and related matters. The best leases leave no issue open to dispute or misinterpretation at a later date. Use of the premises. The property owner may restrict the use of the leased premises by including a special provision in the agreement. For example, restrictive clauses prevalent in office leases might restrict the tenant to using the premises for the purpose of carrying on a general insurance agency only and for no other purpose. Residential leases will state that the property is to be used for residential purposes only, not for a business such as opening a child care center or an illegal purpose such as dealing drugs. Rights and obligations. The lease should set forth the rights and responsibilities of the landlord and the tenant. Briefly, the landlord is obligated to provide the property and usually reserves the right to re-enter and to collect rents. Tenants can expect quiet enjoyment of the rental unit and are obligated to pay rent, to not damage the property, and to respect the rights of other tenants. A more detailed discussion of rights and responsibilities follows. Building rules. Most leases for multiple occupancy buildings, residential or commercial, have an auxiliary section entitled Building Rules. These rules are usually made part of the lease agreement by reference and provide a more detailed treatment of day-to-day matters, such as the tenant's use of common areas, parking spaces, and hours of building operations. They are designed to protect the condition, reputation, and safety of the property and to promote compatibility among the occupants. Condemnation. Most lease forms also include a clause providing for equitable cancellation of the agreement in the event that the tenant is denied use of the property because it has been either appropriated or condemned by a government agency. Compliance clause. All leases should include a compliance clause that identifies which party is responsible for complying with any new local, state, or federal regulations. For example, commercial properties may require physical modifications to comply with the Americans with Disabilities Act ADA. Assignment and subletting provisions. Provided that the terms of the lease do not prohibit such activity, tenants have the right to assign or sublet their interest in the property. Assignment of a lease transfers all of the tenant's remaining right in the property to a third party, whereas subletting transfers only some of the tenant's interest transfer of part of the premises, transfer of the premises for part of the remaining term, or a combination of both. Most leases prohibit the tenant from assigning or subletting the rented space without the owner's prior written approval. This ensures that the owner has stable and financially secure tenants occupying the property. State statutes, however, have been passed in some jurisdictions modifying the unlimited right to prohibit assignment. Fire and casualty damage. State statutes and lease provisions for fire, loss, damage, and property restoration vary widely. When drafting a lease, the manager should keep in mind the types and amounts of insurance to be carried on the property, who will pay the premium, and who will receive the proceeds if there is a loss. It is very important to remember that landlords can only insure what they own and cannot insure the tenant's property. Tenants must acquire their own renter's insurance. Leases for agricultural land or for land upon which the tenant has constructed a building usually remain in force even when the buildings on the property are damaged or destroyed. By the same token, a tenant who is the sole occupant of the building is said to be leasing the underlying land as well. Under most state laws, this tenant's rental obligation continues even if the premises are damaged or destroyed. Other clauses. Other clauses may be added to the lease, provided that both the landlord and tenant agree to the provisions. Some owners may include a termination on sale clause when they intend to sell the property before the end of the lease. If the tenant agreed at the time the lease was signed, then the tenant's lease expires when the property is sold. Many lenders now require a lease subordination clause as a requirement for the mortgage loan. This clause allows the lender to terminate the lease if foreclosure takes place. Commercial tenants are generally opposed to such clauses, especially if they have made substantial improvements in their location. A non-disturbance clause may be a happy compromise. This clause allows the tenant who is current with rent and is otherwise compliant with the lease to remain in the property, even if the lender has foreclosed. Still, lenders often insist on an appraisal to determine that the rent is actually fair market and that the lender is not responsible for rents and deposits made to the delinquent owner. An estoppel certificate letter provides information to a third party, often a purchaser, about the property rights of the existing tenants. Tenants are asked to certify certain conditions if the lease is in operation, conditions that the landlord has done or promised to do, whether security deposits or advanced rental payments have been made to the landlord, payments for utilities, oral agreements, or more. Tenants' obligations. Tenants are required by law to comply with local building and housing code provisions regarding health and safety. They should be required in the lease to take good care of the rented space, repair any damage they directly or indirectly cause, and comply with all applicable rules and laws. The terms of the lease should demand that tenants use all plumbing fixtures, elevators, and other facilities in a reasonable manner. Tenants should be prohibited from willfully destroying or damaging the premises, or allowing others to do so, and from disturbing the quiet enjoyment of other tenants. Tenant improvements. Tenants should not be allowed to make alterations without advance written consent from the owner, who must be informed of such alterations and protected from all liabilities arising from them. In general, most tenant improvements to property are classified as fixtures and become part of the real estate. However, a commercial or industrial tenant may be given the right to install trade or chattel fixtures for business use. These are the personal property of the tenant and may be removed before or upon expiration of the lease agreement, provided that the building is restored to the condition it was in when the tenant took possession. Security deposit. State laws vary regarding security deposits, particularly how they can be retained, what documentation is required, and the return within a certain period of time. While security deposits are not required by law, some states have imposed a maximum amount allowed for residential security deposits. Prompted by the Uniform Residential Landlord and Tenant Act, many states have passed security deposit statutes. These are becoming more detailed and stringent. Property owners' obligations. The landlord manager also has certain obligations. Unless a net lease is involved, the owner generally is responsible for maintaining the property and providing certain services, such as snow plowing, groundskeeping, and cleaning certain public areas. Disclosure and billing. On or before the beginning of a tenancy, the owner should disclose in writing the name and address of the property manager and of the person authorized to receive legal notice on behalf of the owner. The lease should provide that rent bills and other notices can be sent to the tenant by registered mail, left at the premises, or delivered personally, as long as they are submitted at the appropriate times. Quiet enjoyment. The owner or property manager grants the tenant a covenant for quiet enjoyment as one of the major benefits in the lease. This right to use also implies a right to possession. Because the tenant is thereby given the exclusive use and possession of the space, the terms of the lease must limit the cases in which the owner or manager is allowed on the premises. Most leases allow the owner to enter in emergencies and for necessary or agreed upon repairs and to show the space to prospective tenants for a given period near the end of the lease. A clause should be included to permit showing prospective buyers the property in the event the property is placed on the market for sale. Managers leasing commercial and industrial property should reserve the right to enter and inspect the premises at will. This is the only way to ensure that lease provisions are not being violated, that the space is being used properly, and that no unauthorized building or alteration is underway. An astute property manager can predict a tenant company's expansion or impending failure from periodic inspections. Maintaining the premises. The lease and state statutes often indicate repairs that are the responsibility of the owner. Most residential and commercial leases, and even some industrial leases, hold the owner responsible for all repairs necessary to keep the premises fit for use. The owner or the owner's agent must comply with local building and housing codes by maintaining in good operating condition all elevators and other facilities, as well as electrical, heating, and plumbing systems. Unless the property is very small or under a net lease, the owner tends to the upkeep of common areas, trash removal, window cleaning, and other services promised in the lease terms. Running water, A reasonable amount of hot water and heat during the required season are usually supplied by the owner unless the tenant has exclusive control over these installations or unless the building is not required by law to be equipped for these purposes. Under some leases, the owner must furnish utilities. In others, such as the triple net lease, the tenant has to pay for any or all utility services. If submetering is legal, the owner may buy utilities such as electricity at a lower rate and resell them to the tenants at the prevailing rate. This is common practice with office and retail space. In any case, the lease should outline the owner's and tenant's responsibilities for providing services and maintaining the property. The manager should try to draft a lease that relieves the owner of responsibility for maintaining the premises and supplying service if compliance is prevented by conditions beyond the control of the owner. The lease should further state that if the property is sold, the obligations of the owner cease as of the date of sale, with the exception of the responsibility to return or transfer security deposits to the new owner. Tenants' remedies for non-compliance. Tenants have rights when the landlord agent cannot fulfill the lease obligations. If corrective action is not taken within the specified time, the tenant can sue for damages, obtain a court injunction directing the owner to remedy the breach, or terminate the tenancy. If the owner's noncompliance is willful, the tenant may also recover reasonable attorney's fees. Again, state statutes and the wording of the particular lease agreement in effect will affect the procedures and outcome in any situation. Noncompliance with rental agreement. If the property owner or manager fails to perform the required duties, the tenant may sue for damages or terminate the lease by giving the owner the specified notice for breach of contract. Many leases require that the termination proceedings stop if the owner or property manager begins a good faith effort to remedy the breach by the deadline stated in the termination notice. Remedies will vary depending on the lease. For example, under most residential leases, if the property owner or manager fails to perform the required duties, the tenant may sue for damages or terminate the lease by giving the owner the specified notice for breach of contract. The law may require the termination proceedings to stop if the owner or property manager begins a good faith effort to remedy the breach by the deadline stated in the termination notice. However, in commercial leases in which the landlord's covenants may be independent, the tenant may not have the right to terminate the lease for noncompliance by the landlord, but may be limited to a suit for damages. Failure to deliver premises. Some states require the owner to convey only the right of possession of the leased premises to the tenant. In others, the owner must grant actual occupancy. If the right to possession or actual possession is not conveyed, the tenant does not have to pay rent. The tenant can terminate the rental agreement or sue for specific performance and thereby obtain possession, reasonable damages, and attorney's fees. It is not uncommon for a property manager to be unable to deliver possession because the previous tenant has not vacated the premises or because repairs and alterations have not been completed. The manager should protect the owner's interests by including a covenant postponing the beginning of the term, if necessary, waiving rental payments until the tenant is given substantial possession, and requiring the tenant to take the space even if there is some delay. Failure to supply essential services. Constructive eviction occurs when the tenant must actually abandon the premises due to the owner's negligence in supplying essential services. Examples of constructive eviction include failure to supply heat or water, repair premises, or other major material defaults that render the premises unusable by the tenant. Constructive eviction is recognized by most state courts as the basis for termination of the lease, for an action to recover possession, or for a suit for damages. For the owner's protection, the lease should require the tenant to give notice of any failure and allow the owner time to remedy the situation before the tenant claims constructive eviction. Some state statutes prohibit the cutoff of utilities to residential tenants, even if rent or utility payments are owed to the owner. Partial eviction occurs when a tenant has not physically moved out, but is unable to use part or all of the premises for the purposes intended in the lease due to failure on the part of the owner. In cases of partial eviction, state statutes sometimes allow the tenant to give written notice of the breach of contract to the owner. After allowing time to correct the breach, the tenant can take appropriate measures to obtain the services needed and then deduct the cost from the rental payments. In other cases, the tenant may simply be allowed to withhold rent until the breach of contract is corrected. Owner's remedies for noncompliance. Tenants can lose their lease if they do not comply with the rental agreement, such as not paying their rent on time or not at all, seriously damaging the property, annoying other tenants by excessive sound, and so on. non-compliance with rental agreement. The owner is provided with certain remedies in case the tenant fails to meet the terms of the lease. According to most leases, the owner may deliver written notice to the tenant within a specified period, stating the nature of the contract breach and calling for a good faith effort on the tenant's part to repair the breach within a reasonable time to prevent termination of the lease. Sometimes the tenant has agreed in the lease to pay attorney fees as well. Suit for eviction. Eviction proceedings can be brought against a tenant for several reasons: non-payment of rent, illegal possession of the premises after termination of the lease, unlawful use of the premises, non-payment of charges attributed to the tenant under the terms of the lease, and certain other breaches of the lease contract. When a tenant has failed to perform in one of these areas, the owner may file a court suit for recovery of the premises after giving the tenant required legal notice. This proceeding is commonly known as a suit for eviction, a suit for possession, or a forcible entry and detainer suit. If the court issues a judgment decree for possession in favor of the owner, the tenant must peaceably leave, or the owner can have the decree enforced by an officer of the court, who will then forcibly remove the tenant and the tenant's belongings. This process is known as actual eviction and is discussed in more detail in the unit-tenant relations. Bankruptcy. Because of changing federal bankruptcy laws and court decisions interpreting them, property managers should review bankruptcy default clauses in leases with an attorney. Advice should be sought to determine proper procedures to follow if a tenant declares bankruptcy. Tracking rental payments and generating late notices is much simpler using software management. Of course, the timeliness and accuracy depend on correct inputting of the original information. For example, the manager initially lists all of the recurring charges, such as the monthly rental payment, pet fees, utility payments, and so forth. Then, the manager can specify the grace days enjoyed by the tenant until the payment become overdue, triggering a late charge, either a flat fee or a percentage. The software can then automatically generate a notice that a late fee is due, and if not timely paid, will trigger an eviction notice. Of course, the eviction notice must be tailored to meet state and local requirements. Lease formats. Standard lease forms usually are available through the internet and local real estate and professional management organizations. These may be combined with riders and addenda to cover almost any leasing situation. Many larger management firms and property owners have developed standard leases that may be modified to cover most eventualities. Larger buildings, particularly commercial ones, may also utilize their own lease forms. One advantage of employing a standard form is that the property manager can become thoroughly familiar with its provisions and legal ramifications. This benefits a manager who administers a single large property or several smaller properties. When employing standard leases, however, the manager must respect the opinion of the tenant's attorney and the special position of each prospective tenant. Sometimes a standard lease may require considerable revision and may be out of date. Unless the manager is a lawyer, they should not write lease clauses or any form of legal statement that may bind the owner. The manager's or the owner's attorney should advise the parties about leases and riders. Qualifying a tenant. Learning objective, explain the process of qualifying the tenant. Visitor registration. Every prospect walking in the door should fill out a visitor registration. These completed forms are the starting point for discussion. Although not everyone who registers will decide to fill out an application, these registration forms can be used to track leads as well as for documentation that all prospects are treated equally. Lease application. All interested prospects, whether residential, industrial, or commercial, should be required to complete a written lease application. The manager should retain these completed applications for the term of the tenancy. The forms should be saved, even if the tenant does not lease, because the forms can provide written evidence that the manager has accepted tenants based on sound business reasons and not in an illegal discriminatory way. This is particularly important in residential leasing. The lease application form is critical as the manager requires additional information before making a final decision to lease to this particular applicant. The form should be clear, concise, and consistent and cover as many topics as necessary for the manager and owner to make an informed decision to accept or reject this applicant. When dealing with a company or organization, the manager should always attempt to work with the person who has authority to enter into contractual agreements on behalf of that company or organization. Evaluation of data. The property manager must thoroughly verify the accuracy of the lease application, not only the identity but also the financial representations. No one wins if the manager accepts a tenant who cannot pay the rental fees or who abuses the other tenants. Identity. It is important to verify the identity of a residential or commercial applicant. At the very least, the prospect must provide some form of identification individually or as a company or organization, a rental history, financial status, and several references. Residential prospects can supply a government-issued picture ID. Business prospects may be asked for a summary of their long-range business objectives. Most lease applications include a request to allow the manager to check not only the applicant's credit history, but also his criminal history. In commercial real estate, particularly in retail, tenant compatibility also is vitally important. Tenant mix is especially important in retail malls. Moreover, the nature of the prospect's business will have a direct bearing on its compatibility with other tenants of the property. A pawnbroker would, for example, be out of place in a building occupied by attorneys. Moreover, some existing tenants may have leases containing non-competing tenant restrictions. Fair housing. Care must be taken when identifying prospects for residential properties. The manager must be vigilant in following the Civil Rights Act of 1968, as amended, also known as the Fair Housing Act. This federal law makes it illegal to deny a prospective purchaser or tenant on the basis of race, color, religion, national origin, sex, familial status, disability, handicap, and other protected classes added by states and cities. Many cities, counties, and states have added additional protected classes to those named here, making it imperative that the property manager be completely conversant with local requirements. As an example, the Iowa Fair Housing Law covers not just housing but also commercial properties. Rental history. The stability of the tenant's rental history will influence the manager's or owner's final decision. Unless there are valid reasons for doing so, a family or a company moving frequently is often considered a poor rental risk. It is expensive to have a constantly changing pool of tenants, so the manager should seek a family or company that will stay for a long time. It is especially important that the prospect have a stable past record, particularly with commercial or industrial space, which often must be heavily modified to meet the tenant's specifications prior to occupancy. The manager should inquire about long-range business objectives to identify plans for future expansion that could influence a choice between several qualified occupants. Financial status. It is in the owner's best interest to verify references given on the application. The rationale behind validating a prospect's financial references is simple. Slow or erratic payers generally retain this pattern when making mortgage or rental payments, whereas prompt and steady payers are consistent in meeting their obligations. A prospective tenant with a history of erratic and delinquent payments should be turned down. If there are only one or two lapses in an otherwise satisfactory record, though, the prospect should be invited to explain these lapses before a final decision is made. Residential. Brief phone calls to banking and employment references used to be sufficient, but today most managers rely on a credit report. To avoid any appearance of any illegal discriminatory practices in violation of fair housing laws, the manager must show consistency. In other words, the manager should require a credit report from every applicant if required of one. A credit report may be obtained legally only with the applicant's consent and is a history of how a person pays bills. Therefore, the property manager must set up a procedure for obtaining permission. A permission form is usually completed as part of the application paperwork. Many managers charge a non-refundable application fee to help defray the costs involved in obtaining a credit report. The credit bureau will send the manager a report on the financial reliability of the prospect. This statement is an itemization of the status of the prospect's past and current accounts, usually identified by industry bank and department stores. The report will note bankruptcies, collections, charge-off accounts, and current obligations. The quantity and dates of all payments are listed on the report along with an indication of their regularity. The letter indicates the type of account open, revolving, installment, and the number refers to the payment pattern. A rating of 1 is the highest given for payments made as agreed. Bad debts that have been turned over to a collection agency receive a rating of 9. Managers want to know even more about the prospect. A number of companies specialize in searching public records on behalf of the owner or property manager. These searches can include past rental performance history, nationwide credit reports, and outstanding bad check reports, as well as criminal history reports. Rental performance histories contain information such as evictions, past due balances, noise complaints, insufficient checks, and damages to the rental unit. Non-residential. Office, retail, and industrial lease applications emphasize the profit and loss record of the company over the past several years. The economic growth pattern of the tenant is of special significance when leasing retail space in a shopping center, where each business depends on the strength and success of its neighbors to generate the customer traffic needed to make a profit. The financial status of commercial or industrial tenants can be ascertained by consulting a Dun Bradstreet reference book or report. Dun Bradstreet is an international business information company subscribed to by many large management firms. The reference book provides information on the nature and age of each listed firm, along with a composite credit rating and estimated financial strength. Dun Bradstreet reports are more detailed analyses of a single company. They are supplied to Dun Bradstreet subscribers on request and payment of a service fee. The reports list, among other things, assets, liabilities, and officers of all public and some private companies. Lease negotiations. Learning objective. Discuss lease negotiations, including the advantages and disadvantages of various owner concessions, and summarize the final process of obtaining the lease agreement. Negotiating the terms. The negotiating process begins when a prospect expresses definite interest in the space being marketed. Negotiation itself consists of bringing the prospective tenant to an agreement on lease terms that will be satisfactory to the owner. The goal is assigned lease beneficial to both tenant and owner. Because lease negotiations usually involve several steps amounting to a series of compromises won on terms, the property manager must monitor the process continually. Cooperating brokers. An outside leasing agent often is involved in leasing office, retail, and industrial property. In some markets, real estate agents will refer residential prospects. This third-party interest can complicate the negotiation process unless the property manager coordinates efforts with the outside agent. Very early, the manager should attempt to be the party who communicates with the prospect in order to expedite direct negotiations with the prospect without affronting the cooperating broker. It is worthwhile to cultivate the loyalty of the prospect, especially in a tenant's market, for the cooperating broker will have no special allegiance to the manager, the owner, or the space in question. Cooperating brokers should be instructed to avoid quoting price and terms. Often a security deposit separate from the actual rent is held by the owner or manager to be used in the event that the tenant fails to pay the rent or causes expensive damage to the property. The amount of the security deposit is negotiable and depends on the length of the lease and the total dollar amount. Many states require that the security funds be deposited in a trust or escrow account in a bank in that state, although in some states exceptions are made for owners who hold the money. Because the money does not belong to the property manager under any circumstance, security amounts should be deposited directly into a trust account. Also, the 1988 Fair Housing Amendments Act prohibits charging families with children and those with handicaps higher deposits or higher rents than other tenants. And concessions. A concession is a benefit or boon to the tenant because the owner agrees to less than the original terms in order to influence a prospect to become a tenant. While a worthwhile concession alleviates a basic problem or specific financial pressure felt by the prospect, every concession costs the owner money and affects the total economic value of the lease to the owner. A general rule to follow for industrial and commercial lease concessions termed inducements in some markets is that the larger the tenant and the longer the lease, the more acceptable the rent concessions. The owner's cost for preparing and altering the space to suit a new commercial or industrial user must be factored into the rental rate. The rental schedule also should be such that the expense, including the interest on money borrowed, to the property owner will be completely amortized over the term of the lease, but no longer. Free rent. Temporary free rent is the major concession granted to balance the needs of the tenant and the prevailing market conditions. For example, if vacancy rates are high, the manager might offer the prospect 2 months free rent as an inducement to sign the lease. Previously offered as first month's free rent, the free rent has become more common at the back end of a lease to prevent a tenant from moving in, paying no money, and then continuing to live free during the eviction process. The manager should attempt to remain within the basic rental schedule even when offering one-time rebates or other short-term concessions. Hopefully the cost of temporary free rent is less than the loss resulting from a lower rental fee over the term of the loan. In addition, lower rental fees will lower the value of the property when measured on a rent multiple basis, length of lease period. Tenant turnover costs money. It costs money every time a unit has to be cleaned, redecorated, and refurbished, plus the loss of rent. Time and expense are involved in advertising and qualifying, negotiating with a new tenant, so it makes economic sense to negotiate longer leases. On the other hand, the owner can lose money on longer leases unless the lease has an escalation clause covering expense increases. As a result, most residential leases are for terms of 1 year or less. Nonetheless, the manager of a newly renovated building in a newly upgraded area might very well be willing to give 2 year or 3 year leases to financially responsible tenants whose presence over a period of time will strengthen the reputation of the building in the neighborhood. It is a different picture for office and retail leases, which generally have a minimum length of from 5 to 10 years, whereas industrial leases often run for periods of 10 to 25 years or more. Commercial property managers try to negotiate a lease term that is long enough to recover any monies expended to alter the space for a particular tenant. A long-term commercial lease with an escalator clause is definitely to the owner's advantage, but a manager may not want to grant a long-term percentage lease without a base rent unless the prospect is financially sound and has a proven reputation. Tenant alterations. New tenants have widely divergent requests for alterations or improvements before they move in. Negotiation usually involves trade-offs for certain items. As always, the manager must consider not only the type of alteration required, but also its total expense to the owner. An owner who pays for tenant alterations, in essence, is merely financing the costs, which ultimately will be charged back to the tenant in the form of rent. The lease should identify the nature and cost of the alterations and identify the party responsible for payment. If a tenant wants a more luxurious or expensively finished space than the owner can provide, a tenant can be given a straight dollars per square foot allowance. Tenant improvement should become an asset to the property, and no liens should arise as a result of a tenant's work in the building. The property manager must determine exactly what the tenant plans to do and make certain that the tenant can and will complete the space accordingly. ADA. Many businesses and governmental entities will refuse to rent in buildings that do not comply with the Americans with Disabilities Act. Therefore, compliance with the ADA must be discussed with prospective tenants. Negotiations will determine whether the owner or the tenant will pay for the alterations, and specific details should be included in the lease. Tax breaks are available to the party who makes these changes a maximum of $15,000 deduction and a tax credit of 50% of eligible access maximum $10,250 expenditures for small businesses. It is important to check figures with knowledgeable accountants and make sure that any alterations made to the tenant space are in accordance with the ADA's requirements regarding new construction and alterations. The AD mandates that alterations to existing buildings after January 26, 1992 must be made in such a manner that the altered portions are readily accessible to and usable by the disabled. Non-competing tenant restrictions. Non-competing clauses grant a tenant an exclusive right to operate without competition in the property. Most often found in commercial, especially retail leases, the clause also may be relevant to service businesses that are seeking to build client loyalty, such as barber shops. In general, if a non-competing tenant restriction can benefit the prospect without damaging the owner's interests, or if the prospect is willing to pay a premium rental rate for it, the concession should be made. It should not be granted if it would exclude prospective tenants who might otherwise be valued occupants of the building. Some professions do not mind being in close proximity to their competition. It is not uncommon for doctors to flock together, so do attorneys. Managers of large shopping malls should avoid granting exclusive rights at all costs. The total effect of many similar shops in large retail centers is to stimulate business and encourage competition. Signing the agreement. Once the tenant has responded favorably to the premises, the manager's action becomes very important. The manager must first verify and evaluate the tenant's application. If the tenant meets the manager's standards, then the economic viability of the negotiated lease terms must be considered. If the total value of the lease agreement justifies the cost of any concessions, the owner or the manager, as an agent of the owner, will sign the contract and return a copy to the tenant. Closing. The manager's closing techniques can influence the prospect to respond positively to all three questions. A manager can use any of several closing techniques to guide a prospect to a successful close. In one approach, often termed the question close, the manager asks direct questions aimed at eliciting an affirmative decision, for example, which space do you prefer? Another method closes with a summary of the benefits of the space and emphasizes the fact that the space satisfies the tenant's needs. The manager may need to summarize the benefits repeatedly throughout the showing and closing process to reassure an indecisive prospect that the space is ideal. Follow up. The manager must make sure that the new tenant is given a receipt for all advance charges, security deposits, and additional fees, indicating the purpose for which these payments are made. As noted earlier, any security deposit must be handled in accordance with applicable state law.
Okay, case study for the lease negotiator. Harris Wang recently took over the management of Bluff Towers, an office building. After reviewing the leases for the tenants, Wang realized that the lease terms were not particularly profitable for the owner. Because of recent economic slump, the previous manager had leased several spaces to tenants at below market rates and had paid for extensive remodeling. He had leased a great deal of space to three large, rapidly growing businesses, all of which were trying to get out of their leases early because they had outgrown their space. Furthermore, because of the rapid growth, these three tenants, the parking lot has become pretty much a constant problem, and the tenants were complaining. And so, some things we can discuss is what creative solutions can Wang develop to alleviate the problem with the three expanding businesses and requests for getting out of their leases? Well, getting out of leases is tough. But in this situation, depending how this parking lot situation is going, the parking lot and tenants become very unhappy very quickly. So, they might look at it as like a little bit of a loss, but also freeing up that parking space might make everybody's life a lot happier. And also the tenants, meaning like they're going to want to stay there, right? What should Wang do about the resulting parking problems? We just talked about that. And what should Wang do to prevent these type of problems from occurring in the future? Um, well, there's a lot of things that they could have done. I think leasing to rapidly growing businesses is probably not the best situation, especially if you've got limited space, you've got limited parking. So all these things, you think about them before you actually put in the tenant, so that you make sure, oh my gosh, is this tenant going to be good? Is this tenant going to be bad? What type of traffic do they bring? How cooperative with their other tenants are they? So yeah. All right. Well, congratulations. We are done with this unit. See you in the next.